Good morning, everyone. Welcome. It's great to see so many of you here. My name is Kait Bolongaro, and I am the Managing Editor for Europe at MLex. And we're going to kick off today's Data Protection Day with the Organisers Panel called Data Protection Day, What to Celebrate. I have three distinguished guests up here with me today. I have Jo Pierson, who is a professor at the Vrije Universiteit Brussels and the Universiteit Hesse. I have Matthias Kloth, who is the head of digital and governance at the Council of Europe, and Wojciech Wiwerowski, who's the European Data Protection Supervisor. So thank you so much for joining us. Let's just jump right in. Just if you ever feel like answering any of the questions, please feel free. Just take your microphone and jump right in, okay? So let's get started. What do you see as the most significant milestone in data protection over the past decade, and why?
So if I should start, let me first welcome you at this meeting together with the representatives of the Council of Europe and Privacy Hub and CPDP. The CPDP conference for the Data Protection Day is always this moment when we think about the history and the future at the same time. A little disclaimer, by the way, I thought that we will be talking today about the new mandate also for the European Data Protection Supervisor, and I will be able either to present my successor or to give you some hints about the strategy for the next mandate. That's not the case because the selection process is still going on, but we can definitely say the things that will stay in the work of the institutions no matter what will be the leadership of the institutions. Well, if you think about the decade, I think the answer is obvious. That's GDPR of 2016 would be this milestone, but the real milestone is the effective enforcement over the borders. I know that many people here in the room have their doubts about the enforcement development after GDPR, but I have to say that there's an enormous difference between what we had before GDPR and what we have at the moment, mainly because of the work of the data protection authorities and the courts, but also because of the possibilities that are given by the private enforcement, the actions, the group actions that might be organized. These are the things that we still develop, but we can already say that we established a strong mechanism of cooperation between the countries.
Okay, I take over from here. Good morning, everybody, also from my side, and I would also like to welcome you to this event on behalf of the Council of Europe. We're very, very happy to be part of this. Before I get to the most significant milestone in data protection in the last decade, let me just briefly recall the big milestone which has all united us here today. The Secretary General of the EDPS has already mentioned it. It's I think the 19th edition of International Data Protection Day, which marks the anniversary of opening for signature, of course, of the big Council of Europe Convention 108, which was open for signature in 1981. It has been central ever since to the global effort to protect privacy, and it is still, as to date, the only international, multilateral, and legally binding instrument on the protection of privacy and personal data. And I think with 55 parties and observers from around the world, it offers still a data protection framework which can be easily adapted and is a bridge between continents, given that we have members from Africa and Latin America, observers from North America and Asia. So if you can call it, it is kind of a universal treaty for data protection. And if we go one step further back, we can also say the 75 years ago, the European Convention on Human Rights was adopted, which is another major milestone. And it has in its Article 8 the right to privacy. The European Court of Human Rights in Strasbourg is still to date the only international human rights courts where individuals can go directly, lodge an application, and get a binding judgment. And the court has always interpreted the right to privacy as a part of the convention as a living instrument, which can also be developed in view of emerging technologies, which has had a huge impact on data protection. The court has done that, not exclusively, but increasingly over the past decades. And of course, we, as the Council of Europe, we are a pan-European organization with 46 member states. 27 are members of the EU. And as Wojciech rightly mentioned, the GDPR is a major milestone, considered as the domestic law, I would say, of those member states. And of course, we have another famous Article 8 of the Charter of Fundamental Rights, the protection of personal data, and also the very important jurisprudence of the Court of Justice of the European Union. So today, therefore, we can really celebrate the right to privacy as has been imprinted in public consciousness, both globally and in a European style. And then for the Council of Europe, from our perspective, I think the biggest milestone is, of course, the modernization of this 1981 convention. We call it the Convention 108 Plus, which tries to bring this path-breaking treaty from the 80s into the modern age and also give it a modern evaluation and review mechanism and make sure that countries that adhere to it are classified as safe players in the data market. And of course, this is a very ambitious agenda for us. We want to have this convention into force as quickly as possible and also have it as the key standard in public international law and again, as a potential universal instrument for data protection law.
Okay, perhaps I can add to that. So I'm a bit, I think, representing the academic perspective in this panel, replacing Paul de Hert as being a legal scholar. Myself, I'm not a legal scholar. I'm a social scientist looking at media technologies, data-driven technologies, and how the impact on society is. And of course, this also relates a lot to social legal questions. How do we make laws actionable within society, getting popular support, getting all the different administrations, different national governments implementing this in the right way and making it that it really has an effect on society as we want it to have. So I think looking back, we have, luckily, I would say, looking at what's happening now in the world, built quite some great defensive walls to protect us, to have data protection, among others. But even more interesting, you see, I think, how the GDPR has also paved the way for protecting other kind of fundamental rights, human rights, in a way. And we're going to talk about it later also, related to democracy and other issues. Myself looking a lot at news media, disinformation issues, polarization. I think this is quite important to see how data is much more than only this typical legal perspective on data protection, how you also need other kind of perspective being implemented by other types of data-related laws, which we all have now, DSA, DMA, and others. A second point, perhaps, what is striking, you could say, is that the data protection is one of the issues where there is a kind of a total consensus in Europe that this needs to be done by Europe as a whole. So there is not much discussion that it needs to be done on another level. Europe is the party that needs to tackle this. In comparison to other big challenges, wicked problems we have, like climate, there's much more discussion who should do this, and national governments are taking different positions on that. Data protection, luckily, we have a kind of agreement how to do this within Europe, protecting this kind of fundamental human right we have inscribed in the Fundamental Charter and others. So that's a good thing, I would say, which has happened in the past. And we now have these, I would say, defensive walls to protect us from the storms that are coming at this moment.
And to kind of build on that, how would you describe the role of data protection in democracy? Wojciech or Jo?
We have to remember about the roots once again, and to remember that despite we treat data protection as the fundamental right at the moment, it started partly as the political right. In 70s, where we had the growth of the anti-terrorist movement from the Western European states, there was a question: should the police, should the state get so much data about the people, and if so, what should be the oversight over that? So it actually started as a kind of the kind of protection against the overuse or misuse of the data by the government. But we have to say that the personal data protection generally prevents the government overreach and also protects the freedom of expression, because there is no chilling effect of the fact that the public authorities are gathering the data about the people. So that would be the first level of that. But we have to remember also about the building of the public trust and the protection of the electoral system.
Yeah, I think continuing on that, indeed, I think data protection, if you link it to democracy, democracy is about societies, healthy societies, liberal democracies that are able to protect the rights of people and the citizens. And in that regard, I think, yeah, what you look at it, at data protection too much from an individual perspective, which we often see, and from a legal perspective, that's not the right way to look at it when you connect it to democracy. As Daniel Solove and others have claimed, you need to look at privacy as a social value, as something which is more than this individual person that wants to protect his or her individual personal data. So it has an impact on what you can do in society, how you protect it against authoritarian regimes, to what extent you can do stuff which you want to protect yourself, and you can decide how you can live your identity as you want it to be. So I think looking at data protection beyond purely legal individual is very important to make the case regarding the democracy, I would say.
And what role do you think international collaboration should play in shaping global data protection standards?
Whatever we will say about international cooperation will be trivial. We know that the data knows no borders, and actually the data is not flowing over the borders, but the access to the data can be done from the different places in the world. And there is no possibility of building the small island of the perfect data protection without the cooperation with the rest of the world. So then I'm still of the opinion that we should, as Europeans, look to the world, to the like-minded countries which have the similar values and the similar ways of dealing with them as the partners to find the global solution. Although it does not mean that we have to create the lowest common denominator between the countries, and that might be the countries and the regions which we will not find the cooperation level with. But I guess that cooperation inside the G7 or OECD, not even mentioning the Council of Europe as our continental international cooperation, is the core of the activity for anybody who is dealing with the global data protection.
Yo, do you want to add anything to that?
Yeah, I think indeed. I think the international collaboration is becoming much more challenging with recent events. It's clear that America is taking a different path at the moment as to protecting certain kinds of values, to say the least. So the isolist position, looking only at themselves and not looking at the world and how can we cooperate on this, will put more challenges in having this kind of international cooperation and going to the lowest, in that sense, not hopefully going to the lowest common denominator. So I think it's quite challenging. What to do with that, and looking for allies, I think, as Europe, with non-authoritarian regimes, with not polarizing regimes, and looking for ways to have better that protection also on a global scale.
Matthias, what are the key focus areas of your work on data protection this year?
Maybe before I get to that question, just one more thought on international cooperation, because Wojciech kindly mentioned the Council of Europe. I think we have one advantage as a pan-European organization with more member states than the European Union. We have very robust and long-standing frameworks for international cooperation based on mutual trust and based on common values, which is human rights, democracy, and the rule of law. And that can, of course, be a long-term advantage in these times. Now, to the most recent endeavors that we, as the Council of Europe, have, I think a very important moment for us was a year and a half ago, the summit of heads of state and government in Reykjavik, which was the first summit of this kind after 18 years. It was mostly due to the Russian war of aggression against Ukraine, which led to the immediate expulsion of Russia from our organization. But in the outcome document, the Reykjavik Declaration, the heads of governments and states underlines the pioneering role of the Council of Europe in developing standards in emerging and new policy areas. And there are two I just want to briefly mention, which I have a very close connection with data protection. One of them is, of course, our new framework convention on artificial intelligence and human rights, democracy, and the rule of law, which is a treaty designed to help ensure that AI systems uphold our common standards during their life sentence rather than undermining them. And we already heard this morning by the Secretary General of the EDPS about both the promises and the risks that this new technology can bring. And there is a provision specifically devoted to data protection in this new convention, which requires states to ensure that privacy rights of individuals and their personal data are protected and effective guarantees and safeguards are put in place. And for 2025, we of course hope that we can bring this convention to life. We had a very promising start last September when this convention was open for signature. We already have signatures by the EU on behalf of the 27 member states, but also by the United Kingdom or the United States. In total, we have 11 signatories so far. We hope for more. The next possible occasion is the AI Action Summit in 2 weeks in Paris, organized by President Macron, where we hopefully see a few more signatures of this kind. And the second point I wanted to mention, which is also something for 2025 for us to achieve, is the issue of cybercrime. And we all know that the cybercrime is proliferating, and the amount of data hacks and dangers for data protection are enormous. We have in the Council of Europe the Convention on Cybercrime, the so-called Budapest Convention, which goes way beyond Europe. We have 78 parties in total. Rwanda just became the last party. And we have a program office that actually works with 140 countries all around the world to help criminal justice authorities to implement these cybercrime standards in line with human rights standards, including data protection. And I just want to mention that we have a new protocol on cross-border cooperation and also electronic evidence. And that does not just apply to cybercrime as such, but to any kind of crimes. So think about a terrorism act with data stored in other jurisdictions. It's very, very important for criminal law enforcement authorities to get to those data in a very efficient and faster way. And again, we hope for 2025 that we will make progress. We have so far 47 states that have signed this convention, but we need, of course, 5 ratifications for it to enter into force. And that will be a major milestone for us. Thank you.
Wojciech, or you?
Well, it's of course hard for me to answer the question what will be the strategic goal for the EDPS in the next few years, and especially in the next month of this year. But I think two issues are obvious. Well, the first one is the implementation of the law that we already have in Europe, the whole Digital Rule Book and the Artificial Intelligence Act, and the role of the EDPS as the supervisory authority and also the market surveillance authority for the EU institutions. The second point that was already mentioned by Leo in the opening of the conference, in the opening speech, that is digital clearinghouse and the cooperation between the regulators. So the kind of horizontal cooperation of the regulators which are dealing with the digital market. These are the challenges for the institution for next month.
Yeah, perhaps continuing on that, I think indeed the different authorities working together on clearinghouse, there's been called also extended accountability in the literature. So I think that's a very good step forward to see how other pieces of law like consumer protection law, like antitrust can help together protect data protection. So not only GDPR. Still working, yes. Another point I think is very important is, as I mentioned already, looking at more from distance, not pure. Is this how to implement now what has been approved legally? Further, of course, and enforcing the GDPR, but also the new pieces of regulation like the AI Act, DSA, DMA, Data Act, Data Governance Act, NES2, and others. So making sure that they take force, that they are implemented. And for me, that means also looking at social reality. So looking at how does it take practice in everyday life. We recently finished a research share called Data Protection on the Ground, where we looked at the context of different sectors and how data protection really can take shape from a bottom-up perspective. And that's exactly where I think we as social science scholars, as media scholars, can have an important role to connect the legal perspective with the societal perspective and making sure that it takes effect. I link a bit to the introductory speech. We also talked about the power imbalance, the power asymmetry, with a few people having a lots of money and controlling a lots of technological infrastructure. Based on that, that's also, of course, a political economy perspective, looking at follow the money and see how that affects the kind of rights which can be upheld and cannot be upheld again. So that's kind of challenges I see for us as academics next couple of years.
Thank you very much. I'm now going to open the floor to the audience for any questions. We have some participants online as well, but we'll start in the room. No, there's none? Oh, there is one actually right there. There's somebody. Sir?
And also good to see Wojciech again, as always, and representatives from the Council of Europe. One of the things I wanted to touch on, actually, Joe, was what you were talking about, the societal harm when it comes to privacy and data protection violations. And one of the issues I face and many other people in my vast network face when it comes to applying our rights under the GDPR and under the Charter of Fundamental Rights is enforcement of those rights being effective. For example, I'm currently having to litigate against a Swedish supervisory authority for refusing to investigate complaints. They simply close the complaints and send an information letter to the controllers stating that these are not enforcement actions and that they haven't been investigated. So this is one of the problems that we're facing. The other issue we have is access to the courts. The cost of bringing a case to the courts is incredibly high, and the uncertainty around the outcome of that, based on the antiquated notion of what damage is in the court, makes it incredibly difficult for individuals to exercise their rights either with the supervisory authorities or directly through the courts through litigation. So what do you think would be an appropriate way to move forward, and this is both to Wojciech and Joe, in relation to how we can further improve the enforcement of the law, which has been here now for since 2018, and there's a couple of other laws such as the e-privacy directive, which has been here since 2002, and which is still rarely enforced. So how can we move things forward in a way which is going to be more equitable to those in society and help deal with these issues around what is considered as damage under current law?
Well, of course, I'm the first one to answer. And in the situation where you have the complaint in our office and also the complaint is under the investigation, it's not the easiest situation for me to ask you as the complainant to be more active and to push on the data protection authorities. But that's actually the only way of doing the things today, together with the small changes that we do in the procedural laws around GDPR, because I don't expect to have the huge change of the procedures around GDPR in the next few years. There is no atmosphere for this kind of changes right now, and I guess that the making our work more efficient, so that's the data protection authorities challenge, making the complainants to be effective as well, and using the actions like individual actions, like the private actions, is the only way of dealing with this at the moment.
I think what you're saying is actually the challenge I was talking about. So we have these laws; they are great, but they need to take action and need to be implemented in a way that they have an effect. And of course, if you are as an individual citizen confronted with something you not agree with and you know is against the law, making sure that your rights are protected is another thing. So luckily, you are aware of these things. You have the guts to do this. But not everybody has, unfortunately. First of all, not everybody has the data literacy to know about this or the legal literacy to know about this. Even if they have, do they have the money to go that far? If you are against the battalion of lawyers of such a company, yeah, good luck. So that's also a second thing. So I think the way out there is at least making people more and more aware about it. Creating willingness that there is something they can do and awareness about something they can do. That is typically the literacy angle. But then again, you're on the individual level. I think an important step, and this is luckily happening also to quite an extent already, is joining forces. Meaning going to civil society organizations, digital rights organizations, that they take stance for individual citizens. That makes it easy for them representing individuals and taking more action. We all know them, Bits of Freedom, NOIP and others that are doing these kinds of things and make sure that also the rights of citizens that don't have the money and don't have the willingness or capacity of capability to do so are still protected in these cases. But it's quite a battle, I can imagine.
Other questions? Yeah.
I have a question regarding how to balance individuals who want to protect their data and through technical rules and Europe's goal on data protection, because in academia, we are creating technical tools and are researching ways in order to give more control to individuals. However, some of these technical rules could conflict with the GDPR, which is to allow data controllers to process data. For example, the creation of personal data storages and all of these other technical tools. How is Europe looking into these tools to incorporate them into data controllers processing operations and stuff like that, but also to protect individuals, but also to allow the GDPR to be effectively implemented?
Let me jump to the role of the CPDP as the conference. Computer Privacy and Data Protection Conference, the longest existing huge conference here in Brussels, is the place where we do meet as the data protection authorities and as the representatives of the EU institutions with the academia and with those who are developing the tools that you say about. And I can say that most of the knowledge that we have about the tools like that and the software solutions and information systems that you create comes from the meetings with the business and with the academia, the ones like Computer Privacy and Data Protection Conferences. So I'd like to point the importance of this meeting and the meetings like that to strengthen this cooperation.
This fits in a bigger picture, like is mentioned. CPDP is an interdisciplinary conference. I think what is needed is, especially in academia, but also outside, is much more interdisciplinary dialogue. You mentioned it, academics, especially in computer science, developing tools that are privacy safe, to the extent even that they might seen as against the law, what you say, data processors. So yeah, it needs to be looked upon that you're sure they can also be used legally. But I think these kind of tools are quite important to be developed, and that especially public sector, European public sector, gives an example of using these types of alternatives that are more privacy safe. Think about Signal, think about DuckDuckGo, think about all the kind of, in Netherlands you have the Nextcloud now. So alternatives are important. Of course, they need to be legally okay in that sense. That's not my field to check that, but that can be done, I would suppose. But in a sense, it's about finding ways to develop these kinds of tools and being sure they can be used. And luckily, I would say, if you look, for example, at regulation like the Digital Markets Act, there is an idea that these tools also should be interoperable, that if you send a message on WhatsApp, that it also can be received by Signal and vice versa and stuff like that. So that also helps, of course, generating critical mass for these tools. Otherwise, they can't exist. If your friends are all on one platform and not on the other one, you won't move from platform. So stuff like that is very essential for future ways of having sustainable alternatives.
I think we have time for one last question. I saw a couple other hands up. Any burning questions left in the room? Oh,
I have green lights, so I should be able to talk. Thanks for these insights. My name is Simon Hania. I'm a data protection officer at Uber this time. And I would like to up-level the conversation a bit to a global level. Yesterday, I think we all had a wake-up call when all of a sudden stock values of various American companies who are producers of AI tumbled because there is a Chinese open source AI model now getting out there. Is that helpful or is it a threat? Would be my question to all of you. So how do we know? How will we uphold our rule of law against those developments, which are not just AI developments, but maybe a lot of folks don't know, but there's a huge Internet of Things platform that may even be in control over the light bulbs in your house, which is completely Chinese owned. Same with Chinese cars. So there's a lot of data being scraped, not only from the internet, but from our homes to be used for this AI. Is this a common enemy? Is it a friend? How are we going to condition this? That would be my question to all of you.
I probably will not use the word threat or enemy, but I liked the comment on what happened, which said that this is the Sputnik Day for all the societies and all the governments. Sputnik Day, comparing with the situation when Americans got to know that there is a Sputnik in the sky and there was the possibility that Soviets can send the rocket in the space, can also attack with the rocket. So that was a danger. It was never realized in practice. But the Sputnik Day was the moment when the American government and the American society started to think, what are the dangers, what are the possibilities, what are the ways that we should take as the society. So the DeepThink R1, because that's the model which was presented on 20th of January and which created these waves that we yesterday saw on the market, should be the kind of Sputnik Day for all the others in the world.
Can I add to that?
Just to briefly add that this is perhaps a very good example to show that we need some kind of global instrument to regulate AI with like-minded countries on the basis of our common values, which in the case of the Council of Europe, if you articulate it like this, would be human rights, democracy, and the rule of law. And we're very happy that we do have a convention that is global to all like-minded countries that share these values. Thanks.
I think, and also to your question, you need to make a difference between the company and the technology it is putting on the market, DeepSeek R1, versus the technology behind it. I think the company is a Chinese company. If you use that chatbot, it will indeed send a lot of data to this regime in China, which we might not want. But I think what's more interesting about this development is the technology behind it, that it's open source. So this technology can now be used by our own people, our own computer scientists, to look further into as an open source principle. So I think that's a huge progress. This means that the technology becomes much more democratizing. So it also challenges the question about power imbalance. It might help in lifting a bit the power imbalance we have now, that not only companies and people with money will have the best AI technology, but also other countries, European countries, hopefully. So I think it's that's the most interesting part. And so in that sense, I think it's a very good development if that's the case. Now, not all details are out yet, but if it's the case as it seems to be, that it's a kind of an open source angle to help developing these technologies, also with chips that are less expensive than the NVIDIA chips that are now typically being used, so which makes it again more affordable to develop technologies and AI LLMs. So in that sense, I think it's an interesting development which should be closely watched upon, especially also from a European perspective, I would say.
Thank you very much. That's the end of the panel. Thank you so much to our panelists, and thank you for joining us. There's going to be a coffee break now, so if you can just all head out over there, and then we'll see you at the next session.